Today's video is entitled, Slip and Falls Can Happen Anywhere. Can you make a claim? Brought to you by the Mullen and Mullen Injury Lawyers of Dallas, Texas. Slip and fall injuries can happen anywhere, but there are a few common examples where the property owner usually has a responsibility to you. These include retail stores and restaurants, government buildings, schools and universities, apartment complexes, and private residences. A responsible party does not always mean you can make a claim, however. Your status on the property is a huge consideration. Were you an invitee, licensee, or trespasser? An invitee is an invited guest, either direct or implied. An implied invitation occurs when you enter stores, restaurants, and other establishments to do business with them. For example, you go to Best Buy to buy a television, but you slip and fall and injure yourself. You are an invitee because you were at the store to purchase products at their implied invitation. What protections are owed to an invitee? The inviter must warn about or make safe unreasonably dangerous conditions which they actually know about. They must also regularly inspect, discover, and deal with unreasonably dangerous conditions quickly. For example, marking off a puddle on the floor with bright orange cones is a quick and effective way to warn invitees about the danger. If you ignore the cones, slip and fall, and injure yourself, you probably don't have a case. The next status is called licensee. You're a licensee when you're on property that is not open to the general public, but the owner of the property wants you there, but not to do business. For example, when you're on site at work, when you used a ticket to enter a venue, or when you're a guest at a home or a private party. What duties are owed to a licensee? Just like if you're an invitee, whoever is controlling the property must warn you about or make safe any unreasonably dangerous conditions that they know about. They don't, however, have a duty to inspect for dangerous conditions all the time. The final status is trespasser. You are a trespasser if you have no legal right to be on the premises. And there aren't any duties owed to a trespasser. In other words, trespass at your own risk. Attractive nuisance is the only practical exception, and it applies to children. For example, a child who is injured after being irresistibly drawn to a neighbor's trampoline. If you've been injured in a slip and fall, it's important to retain Mullen & Mullen as soon as possible. Our firm will quickly send out spoliation of evidence letters to potential parties directing them to preserve all evidence that could be helpful to your case. For example, many stores have surveillance cameras that might have captured your fall, but they may erase footage if they don't know about your situation. Mullen & Mullen Law Firm has won many slip and fall cases throughout Texas and has the experience to help you. Call Mullen & Mullen for a free case evaluation today.